Hey everybody, it's 3 o'clock, so it's time for our Family Support Q&A. I'm Sharon Spurlock. I'm the Senior Director of Family Support at the St. Louis ARC, and I'm really excited today. We have two experts with us to talk to us about decision-making for people with disabilities and how to think about legal supports for somebody if they need assistance that requires that. Without further ado, I want to introduce you to Misty Watson from the St. Louis County Probate Court. Hi, Misty.
Hello, thank you so much. And thank you very much for inviting us to join you. We're very excited. Thank you to all the participants for logging in today to hear us speak about one of our favorite topics, which is guardianships in the probate court. Just to give you a little bit about my background, I am a recovering social worker who went to law school and then was a probate attorney for a number of years, and then became one of the probate court commissioners. What a commissioner is they are a specialist. Unlike judges that rotate through various divisions, commissioners stay within the probate court. So that's how we differ from judges, but we still make decisions and get to wear our robes and go out in the courtroom to handle the cases. And we're both myself and Commissioner Gust are really the only two people here in St. Louis County that typically would hear any adult guardianship matters. And I know that Sharon, you had asked me to opine on how I have been previously involved in St. Louis ARC. I actually was on the Young Friends Board of St. Louis ARC, as well as a speaker for many, many years whenever I was in private practice on the topic of guardianship versus powers of attorney. And so I have been involved with St. Louis ARC over 15 years. I think it's a wonderful organization that I'm very passionate about the mission. I'm going to turn this over to Commissioner Gust to allow him to introduce himself. I got him involved with St. Louis ARC, and I know he equally is passionate about this area of law. So Commissioner Gust, I'll let you introduce yourself.
All right. Good afternoon, everyone. I'm really excited and honored that you all would want to be here and listen to me talk about what I do. I am one of the two probate commissioners in St. Louis County, along with Commissioner Watson, who you just heard from. I've been, prior to being on the bench as a probate commissioner, I practiced probate law in St. Louis County and City for a large law firm, and I've been a probate commissioner for the last 3 years. Really, along with Commissioner Watson, it's really been our mission to make the probate court a little more user-friendly. I know that it can be difficult and intimidating sometimes to appear in court. And what we've been trying to spend most of our time doing, or much of our time, is to make it easier for individuals to navigate court and to understand what's going on in court. And so we're happy to do this Q&A session for everyone and hope that everyone has some good questions for us.
We want to quickly have a discussion about what the continuum of options are for helping people make decisions, from being an independent decision maker to having full guardianship. So I'm going to step back, and I don't know if one of you wants to start that and then the other one jump in, but let's just kind of set the stage.
So, and I'll kind of take that nice softball from you for a minute, Sharon. You know, whenever we are deciding whether a guardianship is appropriate, one of the things we have to look at by statute are what alternatives were explored prior to seeking guardianship. So guardianship's a drastic option and really is kind of the option of last resort for an individual who is incapacitated. So there's certainly the continuum, like you said, of kind of being that independent decision maker. Are you able to make decisions for yourself all the way up to full guardianship? But there's a lot of areas in between, such as supported decision making. Are there organizations or people, family members that are able to support that individual so that they're able upon gaining more information to make those decisions for themselves, all the way up to are they executing a power of attorney and able to decide who they want without court intervention, making those decisions for themselves. And a lot of this has to do with an individual's abilities to make those decisions for themselves and where that individual is on the continuum.
Excellent. Can you talk just a little bit about the process? We have a question already about what kind of documentation people have to show about what alternatives they may have tried. When you get a case that comes to you, has there already been a lot of legwork, or are there specific things that you want to be able to see in the decision-making process?
Yeah, well, one of the things, once the case gets to us, I would say the vast majority of the time, the petitioner has obtained some type of medical record from a doctor, like perhaps an affidavit or doctor interrogatories, where the doctor has rendered an opinion that this person has a certain degree of decision-making capacity. And so I think that's a really important, wouldn't necessarily say first step, but it would be a good first step when you've gotten to the point along the continuum where you would start to seek the court intervention. So I think Commissioner Watson talked about a lot of options or certain options that you'd have before you get to court, like supported decision-making, power of attorney would be one as well. But I think that if those are options that are really not going to be viable options, at that point, you'd seek the services of an attorney and you'd file an action. You'd talk about filing the action in probate court, which would involve talking to a doctor and getting them to fill out an affidavit or doctor interrogatories. And we've talked about how the guardianship is really an action of last resort. That isn't always something that people will be able to determine before they're in front of us. It's not something so much that the petitioner needs to be worried about. Have I explored all other options? Or we're going to make this, we have to make this decision when we sit on the bench. It's something that we're tasked with making in every guardianship. So whether or not due diligence has been done on the other end before the guardianship has been filed, that's going to be something that we're thinking about and we're thinking through when we're sitting on the bench. And one of the things that we'll pay close attention to is the evidence from the doctors and also the family members. Many times you'll hear testimony from a lot of the family members or several of the family members that will talk about the abilities of, and I'm going to use a term here that's going to sound really legalistic, but the respondent. And that's what we would call someone who has a guardianship action filed against them, where the action's pending. So I say that it's just that's a legalistic term, and it sounds really formal, but it really just means someone whose family or friends are seeking a guardianship action to help them with some of their decision making. And so I think where I was going with that is the whole idea of checking these other options. It's not something we're going to, that you should feel like you have to do this or we're going to kick it out of court. It's something that's part of the guardianship process and that we're going to be thinking about when we're hearing the testimony and seeing the evidence.
Yeah, so full disclosure, audience, I know most of you know that I spend a lot of time teaching about supported decision-making, teaching individuals with disabilities how to make more decisions for themselves. We have a workshop coming up about building a circle of support, because the more people you have in your life that can help you weigh the pros and cons and understand what kind of decisions you're making, the more likely you are to be able to end up being able to make successful decisions for yourself. Having said that, I think it's really interesting to think about how to figure that out. And we've got a parent here who's asking about that 18th birthday. And I think that's one of those triggers for the guardianship conversation, because you're either going to get a letter from the school saying the person is reaching adulthood, or something's going to happen. And can you just speak a little bit to, what about a family member who has a very severe disability? What kind of steps can family take to continue to work with them, but maybe not pursue guardianship? Or when do you think it's time to hire an attorney? Misty, you're nodding. I'll start with you.
So what I think is that it's a good idea to meet with an attorney and at least discuss your options and see what options are out there. So the attorney may say, you know what, yes, we talked about guardianship, but really based upon what you're telling me, a power of attorney is a more appropriate document for this individual to sign so that you can continue to assist them. I know there's just kind of glancing at some of the questions, there's what's the difference between power of attorney and guardianship and conservatorship and all of those things. And we're going to briefly try to describe some of this stuff, but keep in mind, we do 2 to 3 hour presentations. We just actually did a 3-hour presentation at WashU on this last week. So it is, these are really big topics that we're just going to try to summarize down into a couple of words. So first, a power of attorney is a document that your 18-year-old child would sign saying, I'm going to let, and I'm just going to use kind of the generic family, I'm going to let mom and dad be able to help me with decisions. It doesn't give up their right to make decisions for themselves, but allows for a parent who is their power of attorney, or whoever they choose to be their power of attorney, to be able to continue to assist them with decisions. A guardianship is a court process for which you must have legal counsel in order to file that. And that says that is a declaration by our court that they cannot make decisions for themselves. I know in the pre-submitted questions, there was a question about limited guardianship and how do you just get limited guardianship? That's actually bringing it back to Commissioner Gust. That's part of our determination, is what level of guardianship is appropriate. So we have to decide what that least restrictive amount would be. So we hear cases in which medical and placement is the appropriate. We also hear cases in which a parent says, yes, medical and placement is appropriate, but then they tell us all after testimony, it really isn't the appropriate level of guardianship. And we are there to determine what that appropriate level of guardianship is. So we want to make sure that we're doing, that people are aware when they're filing for that guardianship. It really is up to us to decide what limits are put on there, that they don't control that process. Even though they're used to being mom and dad, that you're in a court process and it's really, the judge or the commissioner that's making that decision on their behalf. The guardianship is of the person, meaning that's the decisions like placement, that's decisions like medical, that's decisions like voting, driving, marriage, those kinds of decisions. Conservatorship in the state of Missouri is over the money. So if that individual has money aside from Social Security funds in their own name, then a conservatorship is established. Most cases, a conservatorship is not established because the individual only has Social Security or the bank account with the Social Security in which somebody else is a representative payee. So there's not a conservatorship established. And just because so much has been in the news lately, I did want to clarify that other states call conservatorships of the person something different. So you may hear, and in Illinois, for example, there's guardianships of the person and guardianships of the estate. So, we try to make all of this as confusing as possible for the individual so that no one knows what we're actually talking about. But here in Missouri, guardianship is the person, conservatorship is that person's money or estate, as we call it. here at the probate court. And those are totally separate than being somebody's power of attorney, which has nothing to do with court, but would be something that that individual would do with their legal counsel. So that is a roundabout way of trying to answer about 3 different questions, I think, that we've had submitted.
You did a very good job. Would you want to add anything to that, Commissioner Gust?
Well, not particularly what I agree with everything Commissioner Watson said, which is what I normally say. But there are a couple questions up there that touched on a few things that I mentioned earlier. If I could just piggyback on those, I'd be happy to do so. So one of the questions was, do you review the medical documents, or do you also meet the respondent to validate the evidence? Is any child with a mild intellectual disability vulnerable to claims against him? So I think this gives me an opportunity to talk about the process a little more broadly. Anytime that a guardianship petition is filed in St. Louis County or anywhere in Missouri, Missouri law mandates that an attorney is appointed to represent the respondent. And in St. Louis County, all of the attorneys that the court uses to represent respondents are people that have appeared before Commissioner Watson and myself, and we think that they all do a good job, and they are individuals that will fight for the rights of the respondent if that's what's needed in the particular action. So these guardianship actions, they can be, if you know, they're designed in such a way where the respondent has counsel, whether the respondent can pay for it or not. The respondent has the right to cross-examine witnesses. They have the right to present evidence. They have the right to do anything that defendants or parties to a court action would do. Now, I think that's going to make it sound a lot, that's going to make this sound a lot scarier than it needs to be for a lot of our purposes. It only needs to get that formal and perhaps adversarial with cross-examination if you have a situation where the guardianship is really not something that's appropriate, and you have that adversarial process so that we will be able to take note if someone's trying to get taken advantage of. That's what does not, in 99% of cases, that's not what's going on, but that's the process that's put into place. So you have the attorney represented, the attorney can appear, can cross-examine people. The other thing that's important is I want to walk this back. I want to make this sound a little friendlier now. We had a question where someone says they would like to know what the court setting would look like for their son so that they can prepare social stories to help him understand what he or she understand what they're dealing with. So let me talk about what it is like in the vast majority of guardianships that we have here. So as I said, everyone who's having a guardianship action pending against them has an attorney appointed for them. That attorney will have the opportunity, and they're required by law to meet with the respondent. So if you're the parent and you're seeking a guardianship action against your son, an attorney will come out to your house, and the attorney will call you and will correspond with your attorney. And this is all something that's done on a friendly basis. They'll have the opportunity to come meet the respondent, to come meet you, and they want to make sure that the respondent's in a good situation. They'll have the opportunity, depending on the respondent's abilities, but they'll have the opportunity to meet face to face, to speak with the respondent. They'll probably want to speak with the respondent outside of the presence of the parent or the person that's petitioning, depending on the situation, depending on the respondent's comfort level. But it's their job to make sure that the person that's petitioning is doing the right thing and that it's going to protect the interest of the respondent. Now then, the respondent, so that's just kind of the preliminary meeting. That will be outside of the involvement of the court. We're not, Commissioner Watson and myself won't be at this initial meeting. It'll be the respondent's attorney getting to know the respondent and what the respondent's needs are. After that occurs, there'll be a court hearing. And this hearing, it used to be that before COVID, it would be in the courtroom, everyone would come in, and we would all be in the courtroom. We'd be sitting on our bench, and the two sides would be at the opposing counsel tables. Well, one of the benefits of, if I could say there's any benefit to COVID, one of the benefits has been that it's allowed us to look at some of our procedures. And so now a lot of these guardianship proceedings, if there's situations where it's a parent and a son, or a parent and child, or it's not a contested situation where the respondent is fighting it, it can be done by video. And so the proceeding can take place over video. It'll be similar to you're seeing now. Like you could see Commissioner Watson there in one screen. You could see, if I'm the attorney for the petitioner, you'd see me in another screen. If Ms. Spurlock is the attorney for the respondent, you'd see her in another screen. And then you can also have the petitioner and the respondent appear. And so all the questions are asked over it's WebEx. We don't use Zoom, but it's over WebEx, and everything's done over the computer. The other thing that you should keep in mind on the guardianship process, and if you're talking about to your family members or preparing these social stories for your son, he would have the opportunity to decide whether or not he wants to appear. So the respondent, if the respondent is shy or doesn't want to appear, they can communicate that to their attorney, and the attorney can waive his or her appearance. So that's another thing to think about. The last thing I'd want to mention on this, and this is going to be something that doesn't occur in 99.9% of all cases, probably even higher percentage, it does not occur, but this is another check to make sure that the respondent is getting looked after properly. The respondent, if he or she wants to, they have the right to a trial by jury. And so if they want to be judged by 12 of their peers instead of Commissioner Watson or myself, they can communicate that to their court-appointed attorney, and we will absolutely set it for a jury trial. And we've done that before. That's at the respondent's choice, so the petitioner doesn't get to decide that. The respondent gets to decide that. But that's obviously, we're not talking about the vast majority of cases. I just mentioned that as another protection, a protection in favor of the respondents if they should choose to exercise it.
And I want to know, I want to say, if you're the average family with the kind of average income, you're probably hearing all these attorneys and thinking, that's a lot of money. And, guardianships can be expensive, and there's a continuum. I know that St. Louis ARC has a list of attorneys that do regularly appear in our court, and that they provide services in regards to this for paid, but there are also resources out there for low-income families to be able to file. All families, all petitioners must have an attorney. So this isn't something that can be filed. It's called pro se, which means without an attorney. You must have an attorney to file this action. But there are organizations out in St. Louis that do help low-income families be able to file these. If the respondent doesn't have their own assets, meaning they don't have a bank account or assets in their own name, then the attorney that we appoint to represent them is paid. That those funds are actually paid for by St. Louis County. So St. Louis County pays for that attorney as part of the process.
For the respondent, but not the
Correct.
petitioner, correct?
Exactly.
Okay.
Yeah.
And to my knowledge, just for everybody that asked about money, I'm not aware of anybody that does pro bono work. You can get a lower rate, a sliding scale, but I think there will always be a fee associated with this. And if I'm wrong and no other resources, please send them my way.
We will
get
certainly
that question.
do so, because there are a few organizations there. I mean, I will say there's a 2-year wait list. So, you know, there's a substantial wait list for families, but there are some organizations out there that do take a, you know, on a limited basis, those groups. And I know there's been a couple of questions from parents saying things like, what if me and what if mom and dad aren't on the same page? What if mom and dad are divorced? What does that look like? So one thing I wanted to address is, you know, that basically you cannot file this without notice to the other parent. So the other parent is going to get notice of the hearing. I'll pick on the mom. So if you're a mom and you're filing for guardianship and you're trying to do it without notifying dad, that is going to be a requirement for dad to be notified in regards to this. So dad would be notified of the court hearing, and then have the opportunity to either hire counsel and say, I don't think that this guardianship can approve, or I don't think this guardianship is appropriate, or they can say, no, I want to be guardian in regards to that. Now, if there is a divorce decree, most of the time we're going to look at that divorce decree to say, okay, what was decided in regards to, you know, who was going to make decisions? You know, was that already decided previously as to who's going to make legal decisions on behalf of the child? You know, did a court already make that determination before it got to us? Or is it squarely within us to do that? And please keep in mind when we're talking about things, this is how St. Louis County decides things. There are other jurisdictions such as St. Louis City, St. Louis, St. Charles, things like that they may have a different approach to some of this. Some of this is statutory, and then some of this is how we make decisions. For example, I know our compatriots in Jackson County don't often allow for co-guardians. We don't typically have a problem with co-guardians so long as they're on the same page. So if mom and dad both want to be guardians, even if they're not married to each other, if they think that they can make decisions together, we would allow for them to serve as co-guardians. And then I know we had a question about successor guardians as well, and kind of what's the process once a guardian has been established. So you say who you want to be your successor in your last will and testament, but that's not sufficient. So a lot of times what happens is as you age, let's say you're in, you know, your 80s, and you're like, I want a sibling to of the respondent or ward in that case, to be able to make decisions once I'm no longer there. There may be a point in which you go ahead and petition to have that person serve as co-guardian with you. And then it would automatically just fall to them if something happened to you. If you don't, then they will need to come to the court and after something has happened to you, and there could be a potential gap in decision making. So that's one thing that we try to avoid, because we don't want that falling to the public administrator or somebody like that if there's not a family member that steps forward.
Excellent. Oh my gosh, it's 3:30 and we have had so many great questions. I want to make sure that we let people know that we are going to do this again next week with a little bit different focus, but we're still here to answer your questions. We're going to have just two more questions now and then have to probably wrap up. I think we've got some questions about just kind of trying to decide whether for people that have a lot of skills, but maybe they're not great decision makers, either because of their disability or their age. You know, is it advisable to seek a power of attorney to protect your child? What are some things families can do that maybe want a less permanent solution than guardianship?
I'll just say, I think the power of attorney is absolutely a possibility and potentially a solution. That's all going to, and this is something that I'm not going to be able to answer on a case-by-case basis, obviously, but whether a power of attorney would be able to work is all going to be based on the particular abilities of that individual. And basically, they're going to need to know what are they signing away, and are they entering, do they have the capacity to enter into a contract? So do they have a general idea of what they're signing? The thing to keep in mind, though, with the power of attorney is that it's always, it can always be revoked or essentially just torn up and nullified by the person who signed it. So depending on the abilities of the respondent, should probably dictate whether you go the power of attorney route or the guardianship route. That would be something where you probably, if I were in your shoes, I would want to talk to an attorney to help advise me on that, because it's really going to be a case-by-case situation.
And I will tell, whenever I was in private practice, I would tell parents, it's okay for something not to work. So, that just shows that we tried this and it just didn't work. So, you can try a power of attorney if it's appropriate, and see if that works. And if it doesn't, then seek guardianship. I think people get very hung up on that 18th birthday and think I immediately have to take action. If your child's in an emergency situation, they're going to get treated. So, a doctor, if they get in a car wreck and they have a broken leg, a doctor's not going to say, there's no guardian, they just got to walk around on this broken leg. Like that, from a practical perspective, that's not, something that's going to happen. They're going to take care of that person. So a guardian isn't always necessary right away to be able to make decisions in regards to that. So, I always tell people it's okay to make a decision that we're not making a decision yet. And that we're gonna see how our child does at 18, and see where they're gonna fall in that continuum. Some children mature a lot after they're 18, and are able by the time they're 20 to do that. Guardianship is permanent. It can be set aside, and we'll talk more about that hopefully next week. But that's something that you can look into, but guardianship's a pretty permanent option. And I know there was a question about, should we file right when they're 18? Does that make a difference? And that, we don't say, oh, they didn't file at 18, they're waiting until they're 30, and so we're not going to give them guardianship. That, we really do assess based upon the situation as it is brought to us for that.
I wasn't sure of the question, but I just clarify, if you're the parent, you can't get guardianship. You already have, by virtue of being the parent, you're already a guardian up and until they're 18. So you don't really even need to worry about guardianship, because you're entitled to make decisions, medical and all of that, until your child turns 18. So you really only need to think about it once they turn 18.
I want to say a big thank you to Commissioners Gust and Watson, and I can't wait to have you back next week. And we're going to continue this really, really good conversation. So thank you, everybody, and have a great week.
Thanks for having us.
Thank you.